Welcome to the February 10th session of the Phoenix Congress, where we are writing a blueprint for a better America. This legislative package will end poverty with universal basic income, end mass incarceration with major criminal justice reform, and end the endless wars by bringing our troops home and reducing our military budget. Today's session is the 8th of 21 public hearings on the 2022 legislative package. We will review sections 153, 161, and 162 relative to mandatory minimums and modifying the terms of imprisonment. These sessions will alternate between Mondays and Thursdays at 1:30 p.m. Eastern through March 28th. For those following along at home, you can find a link to the legislative package in the description below or at bit.ly/B, lowercase Dropbox. If you have questions about today's sections, you can submit them in the chat. And if you'd like to offer questions or other testimony for future hearings, please use the link in the description below. Before starting, I'd like to state the preamble to the Constitution of the United States to set the intention for what we are trying to do today. We, the people of the United States, in order to form a more perfect union, establish justice, ensure domestic tranquility, provide for the common defense, promote the general welfare, and secure the blessings of liberty to ourselves and our posterity, do ordain and establish this Constitution for the United States of America. With that, I'd like to welcome the delegate from North Carolina's 8th District to continue his testimony on the blueprint for a better America.
Thank you, Mixed Chair. For the record, my name is Brian. I'm an organizer with the American Union and a Phoenix Congress delegate in good standing. And since North Carolina's, the Supreme Court struck down their proposed 2022 electoral maps, I'm in North Carolina's 8th District at the moment. We'll see how it shakes down in the next couple of weeks. And today we're going to conclude the Weldon-Angelos Justice Act with Section 153, repeal of mandatory minimums. And that's pretty self-explanatory. So we're going to talk about I want to talk about the history of mandatory minimums, some of the theory, and then what this does specifically. In 2016, more than 55% of the federal prison population had been sentenced under a mandatory minimum provision, carrying an average sentence length of 110 months. Now, we talk about them these days. They escalated as part of the war on drugs, but mandatory minimums have been around since the beginning of America. The first 1790 crime bill that Congress passed, it had 23 crimes, and 7 of them had a mandatory death penalty. The rest of them just had maximum sentences. But punishment was different in the 18th century. There was less incarceration. Jails were more to hold people before trial and then hand down punishment. So mandatory minimums, have been around for hundreds of years. When Congress abolished the slave trade, they added some more mandatory minimums. You could get 5 years for bringing slaves into the United States, or 2 years for serving on a vessel that was doing that. And sort of like the drug war today with smugglers, there was this cat and mouse game. And so then they had mandatory minimums for just outfitting a ship for slave trafficking and things like that. It's kind of so the use of mandatory minimums increased in the last half of the 20th century after World War II. And the Anti-Drug Abuse Act of 1896, it really created the framework for a lot of the mandatory minimums that we have today. Now, the premier organization that's working on this issue is FAM, Families Against Mandatory Minimums. They've been around for more than 30 years. They were founded by a woman whose brother got a 5-year mandatory minimum for growing marijuana in Washington state. And the judge told her brother, hey, I'm sorry, that's the law. This is what I have to sentence you to. And so she started an organization to end the practice of mandatory minimums and work on other sentencing reform. And so I'd like to share some of their arguments about why the practice of mandatory minimums should be repealed. One of them is the theories, right? And the theory is that mandatory minimums deter crime and make the public safer. But if you think about that, like deterrence assumes that people are going to like research the criminal code, that they're going to find what the relevant mandatory penalty is and then be discouraged. You'd be like, oh, it's a 10-year mandatory minimum. Well, it was 5 years, then I would commit this crime, but 10 years is too much. People don't know generally what the mandatory minimums are for crimes. And so increasing the penalty and making it more severe doesn't work as a deterrent. Generally, people don't commit crimes expecting to get caught. So what does deter them, though, is catching them and quick serving justice quickly, not just long sentences. One of the other theories is that mandatory minimums will create consistency or uniformity in sentencing. And that's sort of one of the reasons that they came about, was that, you know, you might hear about somebody who got off with not enough prison time. And so the idea was, well, if we set a mandatory minimum, then everyone will have to get this much prison time. And so that'll be more fair. But as a practical matter, it doesn't really work that way, because prosecutors are the ones who decide when, where, and how to charge people. And so prosecutors have enormous leverage in using mandatory minimums at different rates to create sentencing disparities and inconsistencies. In fact, mandatory minimums create racial disparities in sentencing. There's a study of federal sentencing patterns that showed that Black people were more likely than their white counterparts to be charged and convicted of mandatory sentences. According to a 2014 University of Michigan study, researchers found that federal prosecutors were 65% more likely to charge Black defendants. One example would be drug-free school zones, which often require mandatory prison terms for buying or selling drugs within a certain distance of a school. You know, when I lived in Manchester, New Hampshire, and served in the legislature there, you know, there were a half a dozen schools in my district. It was a very population dense area, whereas other representatives, you know, representative places with very low population density, and in high population density area, you're more likely to find people of color, and so they get the hardest hit by these harsh drug-free school zone laws. In New Jersey, before they reformed their mandatory minimums in 2010, Black and Hispanic people made up 96% of the people convicted and incarcerated under the school drug-free zone laws. A couple other theories is that mandatory minimum sentences are necessary to ensure sufficient punishment, and that's mandatory minimums are just a minimum. There are still maximum penalties in the criminal code. So judges can ensure sufficient punishment however they think is appropriate. So eliminating mandatory minimums doesn't mean that people aren't going to be punished or imprisoned. It just means that the courts won't have to do it indiscriminately without considering the factors that matter. And last, mandatory minimum sentences require courts to send people to prison, even if prison is unnecessary to keep the public safe, or they require keeping people in prison past the point at which they pose a danger to others. This is not justice. You know, the name of this section is the Weldon-Angelos Justice Act. Again, he was a man who was sentenced to 55 years on mandatory minimums for selling drugs in a school zone. And the judge, you know, apologized to him and said, you know, my hands are tied. There's nothing I can do about it. This is not a fair sentence, but this is what the law says. And if the law requires us to hand down injustice, then the law is wrong and it should be changed. And so that's what Section 153 will do. It will repeal all the mandatory minimums from the United States Code and let judges judge. Now, a lot of mandatory minimums that are already on the books fall under the drug war. And so those laws have already been wiped away by the first part of the Weldon-Angelo Justice Act. But there are a number of there are 66 other mandatory minimums that exist. And so I did a quick breakdown just to see what the sentences are. Out of those 66, 14 of them have mandatory minimums that are under 1 year. 13 are for mandatory minimums between 1 and 4 years. 8 are between 5 and 9 years. 8 are between 10 and 14 years. 7 of them are for a specific term of years longer than 15. And 16 of these mandatory minimums are a mandatory life imprisonment. Again, this section doesn't reduce the maximum penalty, even if the maximum it doesn't reduce the maximum penalty. It just gets rid of the minimum so that judges are able to take facts into consideration and make an appropriate decision. Some of these, though, are, they're old. Let me share the screen here. And like piracy. So if you are engaged in a piratical cruise or enterprise, or you're part of the crew, and you commit robbery on shore, you shall be imprisoned for life. If you willfully obstruct the escape of any person trying to save their life from a shipwrecked vessel, you can be imprisoned for not less than 10 years. If you're a seaman on a ship and you lay violent hands on your commander to hinder or prevent his fighting in defense of his vessel or the goods entrusted him, you're subject to imprisonment for life. These are some of the mandatory minimums that exist today. And this is not an endorsement of piracy to repeal these, but to say that judges should be able to judge. There are some serious crimes here. And again, this doesn't change the maximum sentences. It just gets rid of the minimums. Now, the states have taken the lead over the last couple decades. Over 30 states have reformed or repealed their own mandatory minimum sentences. And so we can kind of get an idea of what the results would be. In 2017, Louisiana repealed many of its mandatory minimums. And in the first 6 months alone, the state saved $12 million. The state's prison population dropped to a level not seen since the 90s. And then the state was able to reinvest that savings, the money that they'd already had earmarked for incarceration, and put it back into crime reduction and victim support programs. Pennsylvania, in 2015, many of their mandatory minimums were struck down as being unconstitutional. And since that ruling, crime rates have continued to decline, and the state's prison population has continued to decline. And in 2002, Michigan legislators repealed almost all mandatory drug sentences, and the state's crime rate dropped 25% in the decade following their reform. So mandatory minimums do not serve the purpose that we like to think that they do, other than allowing politicians to get tough on crime. But that's not their constitutional duty to get tough on crime. Their duty is to establish justice. And so we can do that best by repealing mandatory minimums. And with that, Mixed Chair, I think that concludes my testimony on this section, and I'd be happy to answer any questions.
Thank you. Yes. Do other countries use mandatory minimums?
They do. Obviously, the United States is the world leader in incarceration, with about 5% of the world's population and more than 20% of the prison population. But some courts in other countries have found mandatory minimums to be unconstitutional. For example, Canada, India, Sri Lanka, South Africa, and Papua New Guinea. I think it's also important to recognize that other countries don't issue such harsh sentences overall the way that the United States does. So in 2016, there were more than 200,000 people in the United States serving a life sentence or life without parole, compared to the United Kingdom, where there was a total of 50 serving life without parole. And so there's just a huge disparity there.
Seeing no further questions, section 153 is assigned to the subcommittee on the Weldon-Angelos Justice Act. You may proceed to section 161.
Thank you, Mr. Chair. All right, section 161 is get into the Matthew Charles Prison Reform Act. Again, I just want to remind everybody, this is a federal piece of legislation. This applies to the federal prisons. And so the prison reforms that are in this subtitle apply directly to the Bureau of Prisons and the 122 federal prisons that are under their direction. Bureau of Prisons has more than, the Bureau of Prisons has more than 134,000 prisoners in their custody, which is more than any individual state. And so once again, by setting the example, by leading by example at the top, we can better establish justice and encourage other states to follow along. I would like to just go ahead and read the findings into the record for this section. And one, the United States has an incarceration crisis that has destabilized millions of Americans and is failing in its constitutional duty to establish justice. Two, more than 2/3 of federal prisoners serving life sentences have been convicted of nonviolent crimes, including 30% convicted for a drug crime. And there are tens of thousands of people over the age of 50 who remain locked up, though they are elderly, sick, and pose little or no public safety risk. Three, approximately 97% of incarcerated Americans will be released. Therefore, it is in the best interests of all to position them to succeed when they are. And so that's a large part of what the Matthew Charles Prison Reform Act does, is tries to reform the conditions to encourage rehabilitation for incarcerated Americans, to set them on a path for success when the vast majority of them are eventually released. That's an essential part of building a better America with this legislative package. And with that, Mr. Chair, that concludes my testimony for section 161, and I'd be happy to answer any questions.
Thank you. Seeing no questions, section 161 is assigned to the subcommittee on the Matthew Charles Prison Reform Act. You may proceed to section 162.
Thank you. Section 162 deals with modification of certain terms of imprisonment. This is modeled, it comes from the Second Look Act of 2019, which was introduced by Senator Cory Booker. And in short, it allows individuals who have been incarcerated for more than 10 years to request a sentence review. And so that was the basis for this section. And it's once again rooted in the belief that individuals are capable of redemption, that people are capable of self-improvement. I'm not the same person that I was 10 years ago. We all change and grow as human beings. And so it's appropriate after a decade or longer to reevaluate, to give a person a chance to be reevaluated and see if the sentence that they've been given is still appropriate. Once again, like the repeal of mandatory minimums, this creates the opportunity for judges to judge. So let me talk more about some of the details in this legislation. One of the reasons that it's needed is because back in the 1980s, federal parole was abolished. And so it used to be after serving, a third of your sentence, you could apply for parole. And parole is to give your word that you've been reformed and you'll behave, and to be let out on the condition that you'll have good conduct. But we got rid of federal parole. And so that dramatically increased the length of prison sentences that people were serving. And then, of course, combined with long sentences, especially with the war on drugs, was really part of the explosion in our prison population over the last 3 decades. And so what this section of the Blueprint for a Better America will do is allow someone who's been incarcerated for more than 10 years to request a sentencing review, or someone who has been sentenced and incarcerated under a law that has been repealed by the Weldon Angelos Justice Act. So the drug war. If a person is serving a sentence for a federal drug crime that is repealed by this legislation, then they would have the opportunity to ask for their sentence to be reviewed. It wouldn't be automatic. It would be, again, it would give the opportunity for judges to judge. On a petition for a sentencing review hearing, the judge would have to hold a hearing. The defendant would be entitled to counsel. Both sides could submit evidence, and in order for a judge to modify a sentence, there would have to be a positive finding. The judge would have to explicitly find that the defendant was not a danger to the safety of any person or the community. They'd have to find that the person had demonstrated readiness for reentry, and they would have to find that it was in the interest of justice to modify the sentence. And only if all 3 of those conditions were met could the court modify a sentence. If they turned it down, people would be able to reapply after an additional 5 years. If they were turned down a second time, they'd be able to reapply after another 2 years. And for incarcerated people over 50 years of age, would also have another opportunity to apply. There are some rebuttable presumptions in here. The rebuttable presumption is that someone who has been sentenced to a term of imprisonment for a drug crime, a drug offense, something that has been repealed by the Weldon Angelos Justice Act, the presumption would be that their sentence should be modified. And so the burden would be on the state or the prosecutor to say that, to prove otherwise. Similarly, for incarcerated people over 50 years of age, there would be a rebuttable presumption that they would be released. The burden of proof would be to demonstrate that they were still a danger to the community, or not ready to re-enter society. A couple other things that this does is it also sets up an annual report, so that once a year, the Judiciary Committee in the Senate and in the House would get a report showing how many incarcerated individuals got a sentence reduction under this sentence, how many got denied, what their demographics were, and their location. Yeah, I think that again, this goes back to the idea that well, the individuals are capable of redemption and self-improvement. In the words of Brian Stevenson, each of us is more than the worst thing that we've ever done. And to that, I would add that by definition, the worst thing each of us have done is a statistical outlier. There are too many people in prison serving long, long sentences without an opportunity for a sentence review. And we can address that injustice by giving people the opportunity after a decade to have their sentences reviewed. With that, Mixed Chair, I think that concludes my testimony for section 162, and I'd be happy to answer any questions.
Thank you. Would this apply to people sentenced to mandatory minimums once they are repealed?
It's supposed to. I guess I'd have to double check I guess the language specifically says an offense which is no longer punishable pursuant to enactment of the Weldon Angeles Justice Act or the amendments made under this act. And so since mandatory minimums, I guess there's still the underlying crime still exists. I think that could probably use some clarification, and be happy to work on it with the subcommittee.
Awesome. Does the victim have any say in this?
Yes. The victim of a crime for which someone is incarcerated, they would be notified whenever the incarcerated person applies for a sentence review. In fact, sentencing review gets added to the list. There's like the Victim's Bill of Rights. And so there's a list of proceedings that they have a right to be heard at, and sentencing review gets added to that list. And then when the judge is considering all the factors that around a sentence modification, they have to consider any statement that that the victim has made. So yes, they would be able to object or support and say, look, this person, this person wronged me, but after 10 years, 15 years, justice has been served. I feel like that they have been rehabilitated, and further incarceration is not necessary for justice. So the victim would have an opportunity to weigh in.
Seeing no further questions, section 162 is assigned to the subcommittee on the Matthew Charles Prison Reform Act. I'd like to thank the delegate for his testimony.
Thank you, Mixed Chair.
The next session of the Phoenix Congress will be held on Monday, February 14th. We will be reviewing sections 163 to 173, which is the remainder of the Matthew Charles Prison Reform Act. This hearing is adjourned.